Okay, we talked about the General Allotment Act. Here's the General Allotment Act a little bit more. These are all available to you, of course. Let's skip this for now, and let's look at, we already skipped that. I don't know, it's kind of out of place. Let's skip that too. Let's go directly to the Curtis Act. The Curtis Act was the actual name was an act for the protection of the people of Indian Territory and for other purposes. Okay, which sounds pretty innocuous, right? And I don't know why this is out of focus, but it seems to be better when you look at it on your own screen. But anyway, you've got it available to you, and everybody knows where to find it. Okay, so those little PowerPoint slides for this unit, and this was passed by Senator. Senator? I don't know if I put it up there. I think he was a representative. He was a congressman from Kansas, Representative Charles Curtis, who was a tribal citizen of the Kansa Nation, or the Kaw Nation. So he was like one of the very first American Indian political celebrities, and because he was, an American Indian, everybody wanted him to sponsor the allotment agreement. Okay, so he did, and but anyway, what this did was it basically said, we should go back to about, we've talked about 1866. Remember, and the treaties and the new Constitution, or the treaties of 1866, mentioned allotment. And then prior to the General Allotment Act of 1887, the federal government was trying to get the 5 tribes to allot, and then eventually they wound up realizing that was going to be very difficult legally, so they went ahead and threw it on everybody else where they could. And then in 1893, the Dawes Commission was created. The Dawes Commission, headed up by Henry L. Dawes, which went into Indian Territory, eastern Oklahoma, and attempted to negotiate with the tribes directly to try to see what was going on, kind of, going to the field and figuring out what was the problem. And they quickly realized that allotment was opposed by every class of citizen within the tribes, with the exception of the non-citizen whites who were living there. And by the 1890s, it was pretty common that the white population, the non-citizen white population living within the Indian Territory, was over 3/4 of the population. So they had arrived in, worked for Native Americans, often farmed their land, sometimes under contract, sometimes just under sort of a gentleman's agreement, sort of like sharecropping or something. But the white population, of course, wanted allotment, and many of them wound up getting onto the rolls. So that 1893, the Dawes Commission took out these, what they would refer to later as the final rolls. The final rolls are basically a census, but an official required listing of all tribal members. Once they got those rolls going, they would be able to begin the allotment process. Now, that placed the Native peoples in a real quandary, right? Because if you sign up for the roll, or if you give a name and you go in and say I'm a tribal citizen, then essentially what they would do is to go ahead and assign you an allotment, or at least they would be ready to allot your land, or allot some land to you. On the other hand, if you were trying to stop allotment, the only thing you could really do is just not get signed up for the rolls. In the meantime, a lot of the non-native people wound up impersonating themselves as tribal members, which was pretty easy to do because of so much intermarriage and sort of the real diverse racial patterns of Indian Territory. One could have blonde hair and blue eyes and be just as much a Cherokee citizen as someone who was, had dark skin and black hair and black eyes. Brown eyes, I suppose. Brown eyes. So it was difficult that way. And eventually, the tribes pretty much just dug in their heels and said, we're not going to negotiate any agreement about allotment. It's not going to happen. The tribal governments were also, at the same time, trying to survive federal legislation, which we will talk about in the next few chapters. While allotment was being sort of imposed, the roles were being imposed, what the federal government did, what Congress did, was it gave more and more power to the federal courts in Arkansas. So the Western District of Arkansas was the federal court district, which was extended into Indian Territory. So essentially the federal government began taking over the role of the tribes. And the federal government did sort of like what Georgia did back in the 1820s and 1830s by basically nullifying tribal authority through federal courts. And of course, the federal government could do that. State governments couldn't, but the federal government actually could. So it began to unilaterally dismantle the governments of the 5 civilized tribes, slowly but surely, through legislation as well as court decisions, but also through the Indian office, through administrative rules. Okay. Well, eventually in 1887, they were at an impasse, and the the Curtis Act was pulled out. So what the Curtis Act was basically a ticking time bomb. If you read through it, it specified the conditions of allotment that each tribe would have to follow, if a tribe did not negotiate a different agreement prior to this date. So it set a date into the near future, and it said, unless there's an agreement prior to this date, then these conditions take effect immediately. Plenary power. All right? And so some tribes immediately, began to negotiate. And the last one to hold out were the Cherokees. But they eventually succumbed, and the agreement was, I believe, 1899, maybe at 1902. But anyway, with the Curtis Act, again, the Curtis Act, like the Dawes Act, didn't actually specify the conditions of allotment at all. It just was a threat. It was and none of the tribes actually were completely subject to the conditions of the Dawes Act, so they negotiated their own agreements. And then the allotment of the 5 tribes is actually pretty complex because of the status of the title. There was no surplus lands, because surplus lands would have been a taking from the tribe. So that meant that every square inch of the domain, of the land, we could call it the territorial possession, every square inch of that had to go to one of the tribal members. And so the condition sometimes led to, there was a huge range in the size of allotments. And there are also 2 different types of allotments, at least in the Cherokee Nation. There were homestead allotments, which were typically the small farms where people lived. And then to get rid of that other land that would have been otherwise surplus land, tribal members received what are referred to as surplus allotments. Okay? So tribal members got their homestead if they were able to, and they usually got another parcel of land, often much larger, elsewhere. But sometimes those allotments were separated by 50 or even 100 miles. I mean, it's possible, 20, 50 miles. And back in these days, people didn't go, they didn't commute 50 miles a day, So this was kind of an issue. Another thing that we need to keep in mind is that because the tribe owned not only the surface rights but also the mineral rights, under the Curtis Act, under the agreements, under all the agreements except the Osages, all of the mineral rights to the lands, to the allotments, passed to the allottee. Okay? Really significant there, because even as lands were being allotted, into about 1910, for the Cherokees at least, they were allotting land at the same time oil was being struck in some of the very first fields, like the Red Fork field on the west side of Tulsa, and later the Glenpool field on the south side of Tulsa. So those were being made. That meant there was a rush of people in, and it caused allotment to be very, very chaotic. So the Curtis Act basically forced the hand of the 5 tribes to allot. The allotment of the 5 tribes was different than the rest of the tribes that underwent allotment after the Dawes Act, in that there were no surplus lands. Okay? This will be, and then that point is actually very important, as we'll see later. Okay. Now, I mentioned we skipped past this. I'm going to back up just quickly, if you don't mind. I'll try to move this on the slides later. But the Berkey Act, have to also say that like the allotment under the Dawes Act, allottees were subject to a restriction period, where they could not sell their allotments. It varied from tribe to tribe because the agreements were different somewhat. The Cherokee example, you received a homestead allotment and you received a surplus allotment. And the homestead allotment was subject to a 21-year restriction. The surplus allotments were subject to I think a 5-year restriction, reduced. But that varied from tribe to tribe. Even before allotment was completed in 1906, enough allottees from the 5 tribes and elsewhere had petitioned the federal government, the Indian Office, to say, there's no reason I need to have this restriction period. Basically I'm completely competent and own other land, and this, having this restriction on me is binding, and it's not fair, because I'm not unable to manage my own financial affairs. Okay, so that's what people would say. Congress responded with the Berkey Act, 1906, and what that did was, for those allottees who desired individual parcels, who desired to perhaps mortgage them to capitalize on farms, whatever, all they had to do was petition the Secretary of the Interior, and then the Secretary of the Interior would rubber stamp, typically, a removal of restrictions. Okay? I mean, there wasn't a lot of, this was the objective in the first place. So a lot of allottees immediately were able to sell the land. And that's why you don't have, 3/4 of the land in the former nations under Indian title today. A lot of it was lost immediately. And this is also the subject of a book that probably a lot of you have heard about. The actual title is And Still the Waters Run, The Betrayal of the Five Civilized Tribes, 1940, Princeton University Press. It would have been published by the University of Oklahoma Press if it weren't for the fact that many of the benefactors of the University of Oklahoma in 1940 had participated in the things that were described, and Angie DeBow actually named them in the book. And so the University of Oklahoma Press said, it's a great book, but somebody else has to print this. We can't do that, okay? Which is wrong. So anyway, the problem, the things that Angie DeBow generally described were the practices of non-Indians obtaining legal guardianship over these allottees who were basically 1/4 or 1/2 blood or more associated with blood quantum, okay? So it was the Berkey Act, and I'll show you the specifics, but the Berkey Act, if you were like 1/64th Cherokee, there was no problem with you having your restrictions removed. But if you were 1/2 Cherokee, then you were automatically assumed to be less than competent. And so, and if you're a full blood, so-called full blood, then you weren't going to have your restrictions removed. Okay, this is the the government acting as your great father and protecting its wards. In Angie DeBow's book, by the way, Angie DeBow, I don't know if you know, was the map librarian of all things at Edmund Lowe Library back in the 1950s and I think into the 60s. After this was all published, she was actually very well known. Yeah. Yeah, there's an Angie DeBow room on the second floor. If you go through the central hallway and you get up to the landing on the second floor, you go like toward the elevator, you'll see the Angie DeBow room, and they have all of her. They have her collection there. Basically, she donated the collection from her house over here in what's the name of that town? Marshall, Oklahoma. So basically, the judges. Judges and the courts, I should say, the courts would publish lists of orphans and lists of native allottees who were judged to be, like half-blood or full-blood, who were therefore unable to have the restrictions removed. And if that was the case, then representatives of those individuals, okay, who were often paying the individual to represent them, would take control of the land, of the allotment, have the restrictions removed, take control of it, and then lease it out to cattlemen or lease it out to farmers. And the way it worked was that the white person, usually the lawyer, received the income and then took over the trust from the federal government. And that, as a trustee to that allottee, he was supposed to convey that income to the allottee, who was restricted and legally incompetent. And so, according to DeBow, there were certain lawyers who would fight. I mean, they would literally fight over gaining orphans and gaining trusteeship over orphans, and then use that land to lease it, and then they would take their share, which is 90%, okay, as the trustee. So it was a legal, very unethical legal land grab, or at least it fell into the hands of people who knew how to work the system. There's actually a book, very thick book, in the library, a whole bunch of them, called, and they're all the same book, called Oklahoma Indian Land Laws. And everybody, all the lawyers who participated in guardianship, essentially this is like having land. It's just not yours to pay taxes on, but you get the proceeds from it, and you're entrusted to convey those proceeds over to your benefactor, to your the allottee.
Do you think that these kids that were adopted, do you think that some of them were never found out that they were adopted or anything like that?
Well, what happened was the
under dark or whatever, the kids might not have ever known.
Yeah, absolutely. Absolutely, yeah.
I have a really weird story, but my grandfather did a DNA test a couple years ago, and he found out he's 1/8 Native American.
Mm-hmm.
And he had no idea he was Native American, but he does know his grandmother was adopted. So, and he's from Tulsa.
Okay, yeah. So the adoption of Native children has been going on. It went on throughout the century, and when we get to the last chapter, well, I don't think we're going to get done before the exam, but chapter 10 includes a section on the adoption laws. And actually, there's a whole chapter on it. There's a whole chapter on the Indian Child Welfare Act. Okay, and so we'll talk about that. But what we're getting at here is that the rolls are closed. The rolls had a deadline, and so everybody was allowed to come in and get their names on the rolls if they could prove that they were a tribal citizen. But after a certain date, all the rolls closed. Bingo, that's it. Well, of course, there were people, there women were pregnant. And so it's unfair to say, okay, well, because I had a child. And there are also orphans and orphanages and so forth. So they went through and they had a newborn roll. In fact, most tribes had a newborn roll and an orphan's roll. And there were also Native people who came into Indian Territory during the 1890s to get allotments. Like a lot of Choctaws that were living in Mississippi came to Indian Territory to get on the Choctaw rolls. So, and that caused, as you can imagine, all kinds of controversy among the tribal people. So the guardianships themselves became commodities. Those began to be traded like stocks, like futures, because essentially you're trading the profits from land that might even be producing oil, and so there's enormous profits coming from that land that the allottee can't even enjoy because of the restriction. So what happened, these lawyers came in and acted as middlemen to allow the development of the land and then transfer the profits directly to the trustee. But of course, there was an enormous amount of fraud that took place. And because the Indian office was based at Union Agency in Muskogee, the United States District Court was established at Muskogee for the Eastern District of Oklahoma. And so the United States District Court at Muskogee became, during this period, during allotment, the busiest federal courthouse in the United States, which was pretty amazing. And it was all because of land titles and hearings for, gaining guardianship. All right, so this is you've seen the Curtis Act. Here's a different act. Okay, well, this is actually, the Berkey Act was specific to tribes allotted under the General Allotment Act. I didn't specify that. The 5 tribes had a different version of the Berkey Act in 1908, and this is what the guardianships were under. Okay, so it doesn't really matter. But the title of this law was an act for the removal of restrictions from part of the lands of the allottees of the 5 civilized tribes and for other purposes. Okay, so May 27th, 1908, it's basically, think of it as the 5 tribes Berkey Act that removed restrictions. Now, the specifics of the 5 tribes is based on, there are 2 types of allotments, or homestead and the homestead allotment and the so-called surplus allotment. The total acreage varied per allottee. It was typically more than 160 acres. This is weird. I mean, this is the weird part. There were some lands that were reserved from allotment. We would call those segregated lands. Okay, it has nothing to do with race. They were segregated from the general allotment process. And town sites, okay, because in 1900 there were towns all over the place in Indian Territory. So if somebody owns a business building in the town of, let's say, Fort Gibson or the town of Pryor, Oklahoma, Pryor Creek, what if somebody received an allotment of 160 acres and got that whole town? That would be a mess, wouldn't it? They would be either really rich or they wouldn't get anything, something. So what the federal government did was they went in before allotment and they segregated off all the town sites. And they said, okay, this land right here cannot be allotted. It's going to have to be dealt with in a different way. They also did the same thing with the higher quality stands of timber, particularly in the Choctaw Nation. Choctaw Nation, is where we have the Ouachita National Forest now. So there was a lot of timber that was, it wouldn't have been suitable for allotting to someone for a farm anyway. So they reserved that. And then also coal mining. Coal mining was already well developed in the area around McAllister, Krebs, Savannah, Alderson, Bocoche, all those towns. And so, the tribe, the Choctaws were making a royalty off of that. So it wouldn't make any sense to say, okay, now somebody new owns all that. That wouldn't be fair. So, but other than those, most of the 5 civilized tribes' domain was divided among its citizens. Okay? And there were no, at least intentionally, there were no non-Indians who were supposed to receive allotments, but there were probably, there are a lot of people who were on the rolls and they're officially Indians, but they're, maybe not genetically, They could have been legally, because J.J. McAllister, for example, the coal magnate in McAllister, John J. McAllister, or maybe it was just J.J., married into the tribe. He was a white man. He married a Choctaw woman, gained Choctaw citizenship. So he had a status as, he was just as much a citizen as someone born into the tribe, but he was not Native American. All right, so as I said, the 5 civilized tribes' land were treated as estates, so there were no surplus lands opened. And the so-called mixed bloods, the intermarried white citizens, and the freedmen. I forgot to mention the freedmen. Basically, the members of the tribe who were slaves and the descendants of slaves and were freed, they remained, a very distinctive population within Indian Territory. Often extremely discriminated against by people within the tribe. Okay, so for example, a lot of the Cherokee freedmen after the Civil War were terrorized and, they left and went to the Creek Nation around Muskogee. Some went to, Seminole Nation, but there was, a lot of animosity about the status of the freedmen. But, and there's still issues associated with the rights of people who were considered freedmen within the tribe. Seminole case, last 10 years, for example. All right. The mineral, as I said, the mineral rights were allotted with the surface rights in the 5 tribes agreements. Now here's where it gets weird. I mean, this is hopefully you'll see the inequities here, but as an allottee had a homestead allotment and a surplus allotment, if you were an intermarried white, a freedman, or a mixed blood of 1/2 or less, or I guess it's just less than half blood, then the Berkey Act simply removed the homestead and the surplus restrictions. Bingo, 1908, you can sell it, okay? If you're white, black, or less than half. If you're 1/2 to 3/4 Indian blood, okay, and this all it just means, if 1/2, that means one parent, well, typically it doesn't have to mean that, it could mean something other, but if the blood quantum based on your ancestry equaled 1/2 to 3/4, then the homestead was not removed. The restriction on the homestead portion of your allotment was not removed, but the surplus allotments restrictions could be removed. And this was a big one, okay, because there were a lot of people who were more than half, but not full bloods, who lived traditionally, never saw their surplus allotment, and basically somebody may have shown up at the house one day and said, "Hey, would you like $100?" And you imagine, like in 1910, $100, what would that be? To someone who doesn't even have any cash. Here's $100. I'd like to buy your surplus land. Just sign right here. This is a quitclaim deed, and then signing over to me. And here's a witness for the what do you call it? The notary. So basically, a lot of people just simply handed over very valuable mineral land. A lot of these surplus allotments, and Angie DeBow talks, she gives lots of examples. Typically, you'll have a 45-year-old Native American woman of half or 3/4 blood living in, let's say, Stillwell, living in a hollow back in the Ozarks. And the surplus, and she has, maybe a 20-acre or maybe a 40-acre surplus or 40-acre homestead allotment, which is her farm, where maybe she was raised, and where she, made a living. And the rest of her allotment may be 160, maybe 320 acres. It could be more than 160. Maybe out in what is today Washington County, near Bartlesville. Okay, and remember, the mineral rights went with the allotment. She never saw that, but somebody may have dropped by and said, "Hey, would you like to sell that land that you've never been to and you never will go to?" And they'd sign it away. The 3/4 to full blood, they still had to petition the Secretary of the Interior in order to have the restrictions removed. Okay, and then restrictions were were valid until April 26, 1931. Is that right? And what happened here is that in 1934, under John Collier, when Franklin Roosevelt appointed John Collier to be the head of the Office of Indian Affairs, Commissioner of Indian Affairs, he immediately stopped all allotments. Well, there weren't a lot of allotments being made, but he immediately extended the restriction period for all allotments. So there was a period between like 1931 and 1934, when restrictions could simply be removed by the Secretary of the Interior at request for anybody. So a lot of land was lost right before John Collier came into office. Any questions over that? It's a lot of material. It's maybe if you have if you're confused about any of that, just let me know later. More on the Berkey Act. I think I have 3 cards on this, at least 2. There were also railroads that were existing, that were already built across the region. There were roads even that, automobile roads that were being constructed, and so those lands were subject to eminent domain by the federal government and handed over to the railroads. So those are some important pieces of land that were that were not available for the allotment process. All right, so in the this is significant. The county courts in the state of Oklahoma, the county courts were given authority to basically do the job of the federal government, because the federal government couldn't keep up with the huge volume of requests. So allotted land that was not restricted, homestead, okay, if it were under the Berkey Act, if it were the surplus allotment of a 1/2 to 3/4 Indian, then those could be adjudicated at the county level, the county courts. So the state of Oklahoma basically received sort of the federal authority over Indian affairs during this time. And that's one of those pieces of legislation in which the Oklahoma, the state officials in Oklahoma point to as Oklahoma's different because the federal government basically, made it a public law 280 state back in 1908 in a lot of ways. If you're familiar with public law 280, which we'll get to. I mean, it wasn't real overt, but essentially they handed authority to the state, and the county courts took over. Now, of course, once restrictions were removed, that placed that land on the tax rolls. Okay, so you got if you had a patent to the land from the United States, then that was converted into a title or deed filed at the county courthouse, and that entered the tax rolls. So that land could be taxed for at what we call in Oklahoma ad valorem taxes or property taxes. And that allowed, of course, if somebody didn't pay those property taxes, just as today, if you're a landowner and you are delinquent paying your property taxes, eventually the state, through the county, may place an encumbrance on that land and basically take it and sell it for those back taxes. And these are sold at auction, usually on the steps of the courthouse. So by removing restrictions, that opens up the land to state taxation, gives state authority to it, and it's basically the land has entered the free market now. Okay? Now, This was good for some people because they didn't want the restrictions. They wanted to be able to mortgage their land. On the other hand, if people, weren't used to paying property taxes and didn't have a cash income to do that, they're going to lose that land. So the effects. Most of the lands of the 5 civilized tribes, except for those held by the more traditional populations in their isolated communities, wherever those may be, entered the market when this law took effect. That should be an E, not an A. Took effect on 27 July 1908. And, the idea that, people will often mention Angie DeBoe's book without reading it. It's a very difficult read, trust me. But the fact of the matter is, the land was taken through legal means, generally through the process of guardianship. For some reason, I couldn't remember that. Okay. Guardianship was a legal way of basically taking control of the land and profiting from someone else's property because they were legally incompetent and they couldn't make legal decisions according to the courts. Okay. Let's go into the ramifications of allotment now. All right. So that's about as, yes?
So just in general, what I can see from this is basically saying join capitalism and join our taxes, even though you make zero income because you're a traditionalist society. So either make money for us or don't. That's what I see, because that's what taxes do.
Well, I mean, I guess my interpretation of this would be anytime the government attempts to be benevolent, there are always people who are going to be working the system. And in this case, the restrictions were intended to keep Native peoples from losing their land and from being taxed by the state. All right, and because of those restrictions, those people who could act in their behalf as trustees or as guardians, as you would say, guardians for orphans, trustees for incompetent adults, those people took advantage of their own system to, basically take the wealth from that land. The land could still be restricted, but it might be producing millions of dollars in mineral wealth every year. Some Native people got wealthy that way. Anybody ever been to Gilcrease Museum? Gilcrease over in Tulsa? That's the world's, the center of the world when it comes to Western art in North American Western art, and Native American art too, in some ways, historical. Well, Thomas Gilcrease was a Creek citizen, and he got wealthy because of his allotment. His allotment was part of I think it was the Glenpool strike. And basically he was a billionaire overnight, He traveled the world and collected art. Actually, that was, he did that. He did that. And he lived a great life. So, not everybody lost it. But the fact, what I'm trying to get at is when the federal government tries to do all these things to safeguard, there's always a loophole. There are always loopholes. There are always ways for the devious to take advantage of the system. And in this case, it was lawyers, It was people with law degrees who understood how to manipulate the system. All right, and I don't know, I'm just trying to, present this. I'm not saying that it's always going to fail. In fact, we'll see some examples of maybe federal Indian policy working so that there are, wins and wins, supposedly. Three important terms to know. The first one is referred to as intestacy. It's hard to say. Intestacy, or the reason I put intestacy is because you'll also see the term intestate. Okay, that's not somebody from New Jersey saying interstate. Okay, it's intestate, and that means a situation in which you're an heir, okay, and you don't, the person who left you something didn't sign it off didn't leave a written will, a written document. So if someone dies without having left a valid will, what happens is the person's debts and the person's assets are controlled by the state for a little while until, most people refer to this as the probate process. You say, you want to avoid, like crazy, you want to avoid your estate when you die going into probate, because the state will take most of your money, all right, and your heirs won't get very much. A devise is the giving of a gift of real property in a will. So we'll run into these. And then this one is a real strange one. Escheat is a reversion of property to the state or the sovereign as the ultimate proprietor of a realty by reason of lack of anyone who inherit it, or by reason of breach of condition. That's straight out of a legal dictionary. Escheat means essentially that if nobody's going to claim it, it can't just sit there unclaimed. The state will take it. And since 1983, beginning in 1983, there was a process in which land that was allotted but wasn't willed was just hanging there and we'll see that. But there are laws that have allowed the tribes to take that land back. So they keep it as trust land through escheat. Anyway, just some terms. Now, your textbook author uses a slightly different version of this term, but this is the legal, maybe it's the projector. That's probably what it is. This is the legal term, fractionation, okay? And a fractionated parcel of land is even a better way of describing it. So, you know what a fraction is, right? 1/2, 1/4, 1/8. So when allotted land, since it's held by the federal government in trust, or at least it's inalienable in the case of the 5 tribes, and basically a restricted allotment. If that land is owned by an allottee and that land is restricted from sale, when that allottee dies, the allotment goes to the heirs, right? And over time, the land is conveyed with the restrictions intact. And I put 1934 IRA, that's the Indian Reorganization Act of 1934, which made this continue in perpetuity, basically. If say like, take from my example, if I were an allottee at my age, then and let's go back to like the Dawes Act, because that's easier to understand. The Dawes Act, I would have an allotment of 160 acres, and I would get a patent to that land supposedly in 25 years. Although I could petition the Secretary of the Interior to try to keep the restrictions. Some people did that. But say I die in 20 years, okay? Well, what happens is the allotment, it doesn't keep ticking for 5 more years. If the allottee dies without the lands being taken out of restriction, then it stays in restriction. And what happens is the heirs divide the interest in that allotment. So say I have 2 kids, I die at the age of 75 rather than 80, and my kids inherit that land. It's going to be restricted land, and there's nothing that can be done about that. It's hanging in restriction because I'm dead. And so they would get 1/2 share in that 160 acres. It's possible they could maybe get the Secretary of the Interior to divide it, but not likely. So it's going to remain restricted land with these varying interests. Over several generations, what will happen is, it is possible to divide the interest in a will, but sometimes there's no will. And if there's no will, then the probate process takes over, and anybody who is a descendant of that person winds up getting an equal share according to the courts, which creates an enormous mess. So this is the thing that is really hard for me to understand, and that is that even though this is land that is held in trust by the federal government for the exclusive use of an individual Indian, a allottee, that when that allottee dies, if that allottee dies without a will, then the estate goes into probate. The estate goes into the situation of intestate succession. There's no will. The allotment is subject to state intestate succession laws. That's what I don't understand. So wherever the allotment is, if it's in Wyoming or if it's in Alabama, and there are reservations, or if it's in South Dakota, then the probate laws that are relevant are specific to that state. Okay? That just is weird to me for some reason. It's a state law. Is not. There should be a federal intestate succession law, basically. It should be valid for. But maybe it's not because eventually they assume it's going to go into the land market. All right, so anyway, all of the possible heirs receive an equitable interest in whatever is passed down. And the restrictions on the alienation, then, what they do is they prevent one heir from buying out the others because it's trust land. You can't buy and sell it. Okay? You could buy somebody's share, but that doesn't really mean much. And most people don't have time for messing around with this. So here's an example. Generation 1, and let's just assume there's no will here. Person dies the allottee dies in 1920, has 4 children. There's basically a 40-acre. There's not 40 acres of land, but a 40-acre interest, or a 1/4 interest. Okay, and then let's say. From those 4 children will it to 12, and so it gets subdivided 13 interest, and it only takes about 3 or 4 generations before the interest is so small that it would be more expensive to keep track of the interest in the land than it's even worth. So this is the problem of fractionation. The fractionation takes place over generations. And once you're at a certain point, and if you've read this chapter, there's some really remarkable examples of heirs having, an annual income from the land of like 0.3 cents or something like that, because of their share, because of their interest in that former allotment. If the land was being used in some way for income, like being leased for grazing land or something, so maybe the land is able to generate, $2,000, $3,000 per year lease money. A lot of that's going to go into administrative costs, and then eventually heirs will receive some portion of that. But what the thing I'm concerned about here is not so much what the heirs are getting, but what's going on with the land. The land is not really owned by anybody still, and so it winds up getting just typically not being used at all. And this is a problem throughout Indian country, throughout the state of Oklahoma especially. There's a lot of land out there, rural land, that is in a fractionation state. It's fractionated. And because of that fractionation, it can't really be used. And it's a very difficult, almost impossible problem to try to solve. So this is why federal legislation has been passed in recent decades to attempt to ameliorate this problem called fractionation. Hernando de Soto Pilar is an economist who wrote a book called The Mystery of Capital back in the 90s. And a really easy to read, interesting book, but he points to this idea of dead capital. Basically, it's an asset that's just not usable. And this is what happens to these allotments, is they just hang there and they're not really able to be utilized for any purpose. They're not taxed. The state can't encumber them, but they are not being typically. Basically, land is just winds up being ignored or unused. Well, it's about time to go. Here are some other sort of observations. I'll let you look at those. Here's the Indian Land Consolidation Act, the first attempt in 1983 to try to fix this problem of fractionation. You can look at those later. It's not that important. But this is one of several attempts. And even actually the Indian Land Consolidation Act was, initially it was trashed because it amounted to an inequitable taking by the tribe on its members. Okay, interesting. Okay, well that's it.